Hello, welcome once again to Leto's Law. I'm Steve Leto. Today we're talking more about juries. I have done a few videos recently about juries, why you might not have been selected for a jury. I talked about grand juries. I talked about jury nullification, another common question. Go back and look. I did a video not too long ago about that. And I talked about a bunch of different things about how to select juries and what lawyers are looking for when they pick juries and so on. But I've had quite a few people ask me some more specific follow-up questions. And one question I got asked is, Steve, how come they don't let the jurors ask questions during the trial itself? And it's an interesting thing because some courts do allow it, and I've actually seen a court allow it before. And it's one of those things that attorneys hate. And I know a lot of people say, well, Steve, just because the attorneys hate it doesn't mean that it shouldn't happen. I mean, we don't have to cater to attorneys everywhere, do we? Well, here's the thing. Number one, juries hate it, but I think most judges recognize that if they actually said, we're going to have a trial, okay, it's going to go on longer than we expect because they always do. Every single witness that gets up there gets a direct examination, a cross-examination, a redirect, a recross, and that can go on for a while. And then at the very end, somebody goes, Your Honor, that's all I've got. Somebody else says, that's all I've got. Can you imagine what happens then if the judge turns to the jury and goes, you guys got any questions? And you can see why that would simply lengthen things. And nobody is in favor of lengthening trials. And ironically, one of the people that you think would not want to lengthen the trial is a juror. But of course, you know how it is. You'd be one of 12 people. You'd be going, come on, guys, let's end this right now. And the judge goes, do you guys get any questions? And the juror in front of you is going to raise his hand and go, yeah, I got a 3-part question with 4 subparts each. How should I address these, Your Honor? So that right there is a problem. But the bigger problem is that letting the jurors ask questions suggests that the jurors actually know what the trial's all about. And you might say, well, Steve, isn't that their job? No, because here's the deal. You select a jury, and during jury selection, the jury will be told, here's what the trial's about. They'll be told a thumbnail sketch. It's a car accident case where someone's suing for personal injuries. They're suing the driver of the other car. The driver of the other car says they're not at fault because they were stopped at whatever. And they'll be told this little 2 or 3 sentence vignette of what the case is all about. And by the way, in case you're curious, 99 times out of 100, the two sides have gotten together at the judge's instruction before the trial started, and they were told, you guys create a statement of the case that you can both agree upon. And they can usually do it. This is a lemon law case. Plaintiff claims the car is defective. Defendant claims it's not. I mean, that's, boom, there you go. But here's the thing. Even though both sides will give opening statements where they'll say, here's what we're going to prove. We're going to have witnesses who say this, witnesses who say that. We're going to show you documents that prove this, documents that prove that, police reports, photographs, whatever, accident reconstructions, whatever it is. The jury's told that, here's the roadmap of the case, and the other side says, no, here's the roadmap of the case. If I put my first witness on the stand and walk them through the testimony and the other side cross-examines them, I can imagine many situations where a juror might go, well, wait a second, and start asking questions because they want to know where the rest of this case is coming from. And the attorneys know what they're going to put into evidence, and they know if something's missing. So the idea that a juror is going to spot a question that somebody missed, despite the fact there's 2 attorneys up there working on this, and a judge who's overseeing this whole thing, it's not likely they're going to actually spot something that needs to be brought out at that time. In fact, they're probably wrong. But there's actually a bigger concern, and I purposely put this last because I wanted to put a couple of good ideas out there first so the people who object to this will understand that there's other reasons also. But there is an art. There is an art to doing a direct examination of a witness. You put a witness on the stand, and this is my witness. I've talked to this witness before they put them on the stand. If it's my client, we are both intimately familiar with this case. We both are invested in this case. We spent a lot of time working on this. And so my direct examination of my client, for instance, okay, if I put my client on and my client tells a story, trust me, I'm not leaving anything out. Now you say, well, Steve, you might leave out the bad stuff. That's what the other side does. They get up and they do a cross-examination, okay? And they're going to ask the bad stuff. They're going to poke around, and if it's admissible, they're going to get it out of this person, right? That's what they do. And that thing I just mentioned right there is one of the problems. What if somebody in the jury goes, I got a question. And the judge allows the question. What's the question? Have you ever been convicted of a felony? if that had been asked by an attorney, you'd get an objection because that's not a proper question. Okay? There's a problem with that question. I'm not going to get into the problem with the question. But there are questions that attorneys know that they cannot ask. A juror wouldn't know that. And so if both sides now object and say, Your Honor, it's an improper question, can you imagine a judge telling a juror, you have to disregard your own question? Because you can be told to disregard an attorney's question, but can you actually disregard one that was gnawing at you to the point where you raised your hand and asked it? But second of all, and here's the crazier thing, there's also an art to a cross-examination, okay? And I'm talking about, there's a book behind me. I always turn the wrong way. There's a book behind me called Trial Techniques by a guy named Mowat. And Mowat's book is the Bible of trial techniques. The guy explains how to do a trial. And in it, he has a chapter on cross-examination. And there are two things about cross-examination you have to teach someone who's going to do trial work. And the number one, of course, is you do not ask open-ended questions. You ask on cross-examination questions that are so closed-ended that you don't need the witness to do anything but admit that what you just said is correct. Isn't it true your driver's license was revoked in 2016? Isn't that true? If that statement's true, the only correct answer is yes. You can try to squirm out of it, but you have to admit it's true. Yes, it's true. Okay, you got me. But you don't ask a question, tell me about your driver's license. What's there to tell? No. Cross-examination is laser focused to the point where you are telling the witness, here's the answer you're going to give. And I know that because I have the right to ask closed-ended questions on cross-examination. I know what the answers to these questions are, and I'm going to ask all of the correct questions if I do this right. We always know the saying, don't ask a question you don't know the answer to on cross-examination. So what I'm getting at here is a proper cross-examination is laid out by a good trial attorney, literally question by question or point by point. So I know every question I'm going to ask, and I'm going to tell you something right now, that if there's a list of questions that I want the answers to get to the jury on, there's always one missing question. I do not ask the last question. And that's something Mowat talks about. I didn't invent that. It's an old saying, goes way, way back. It's not as well known among non-attorneys as the saying, don't ask the question you don't know the answer to. But you do not ask the last question. So you might say, Steve, what are you talking about? Yes, exactly. Let's suppose we have a case where a person testifies and they said, you know something, I heard a fight break out. And so my attention was drawn to this fight. These two people were in, and that's, of course, the subject matter of this lawsuit. And the defendant punched the plaintiff in the face. And so then the plaintiff then was using self-defense when he defended himself. And this witness goes on to describe this fight. And so now on cross-examination, I read the police report. And this witness gave a statement to the police. I'm making up facts here for a point. So this witness gave a statement to the police and said, I heard this fight break out, and I was standing at this corner of this intersection. My attention was drawn to this fight, and then here's what happened. And I'm looking at the police report before I go to court, and I realize that where the witness was standing, the witness could not have seen either the plaintiff or the defendant. The fight was taking place around the corner. They heard the fight break out. And the police report says, I heard the fight break out. So on cross-examination, I would have listened very closely to the direct to see if this person ever said they saw anything. Let's assume they didn't. Let's assume they stuck to their police report verbatim. I heard the fight break out, and then plaintiff punched the defendant in the face. Okay? On cross-examination, my first question would be, you spoke to police, did you not? Obviously. And you gave them a report and a written statement, correct? By the way, notice I don't need to get the answers to these. Because these I'm giving you the answers on cross-examination. All you're doing is affirming my version of your testimony. And the police report has your signature on it. Let's assume that they actually had you sign your statement. It has your signature on it, correct? And you spoke to the police officer, the sergeant, whoever it was. Somebody took your statement, and they wrote it down as you were talking to them, yes? Okay. And after they wrote it down, you reviewed it and read it, correct? Okay. And after you reviewed it for accuracy, you signed it, correct? Okay. And again, I'm not getting the admissibility of a police report, but I'm simply saying, let's suppose there's a statement. And I say, by the way, here's a statement, and there's a signature down here. That's your signature, correct? That is your signature, right? Okay, that's your signature. And you testified a little while ago about the sequence of events, and you are under oath, yes? Okay. And you told the truth, correct? Okay. And you also told the truth when you spoke to the police officer, correct? And when the police officer wrote down your statement, the statement was true, but it was also recorded accurately, correct? Okay. And everything that you've testified today is complete because you were sworn to tell the truth, the whole truth, and nothing but the truth. So you have included everything as truth, and you've not left anything out, correct? Okay. At that point, you might actually say, no further questions. Turn around and sit down. Now, I'm hoping you realize what I did there. I did not ask, so you heard the fight, but you didn't see it, did ya? Because as soon as I say that, he's going to go, oh, actually, yeah, I saw it. Now I got to back up and go, wait a second. You didn't say you saw it. You didn't testify you saw it. Obviously, the guy didn't see it, right? But the point is that if I really want to get this across to a jury, okay, I'm going to ask all the setup questions, like I'm teeing up a let's put a baseball on a tee, a stand, like a little kid's tee-ball, okay? I'm teeing this thing up, but it's the size of an ostrich egg, and I got a sledgehammer. And I'm teeing it up. I don't swing yet, okay? I stop. Say, Your Honor, no further questions. Now, my opposing counsel might not know what I'm getting at, or he might know what I'm getting at. But he also knows, probably, that his client didn't actually see anything, or his witness didn't see anything. Okay? His witness heard something and somehow got inserted into this story. So if there's a juror over here who thinks they're Perry Mason or the female equivalent, they might say, excuse me, I have a question. Yes, little Timmy, what's your question? Well, he asked a lot of questions about the fight, and Mr. Leto cross-examined him, but he seems to have missed the most important question. Can I ask the witness, did you see the fight? And of course the witness is going to go, oh yeah, I saw the fight. Witness didn't see the fight. If the witness had seen the fight, they would have told the cop. They would have put it in the report. They would have testified to it. Okay? So one of the things that rookie attorneys do in trials is they can't help it. They ask all these questions and they see it's going perfectly down the lane. It's hooking right between the 1 and the 3 pin. Okay? It's hooking in perfectly. And they can't turn away from it and remind themselves, okay, we're going to pick that up during closing argument. Because if I can do that where I end the exam and say, you testified truthfully, your report was truthful, you reviewed it, you told the cops that, we're good, right? There you go, boom, no further questions. During my closing argument, I'm going to stand up and go, you remember the key witness? He said he heard a fight, but he never said he saw it. You know why? He didn't see it. He swore under oath that he told you guys the full story, whole truth, nothing but the truth, so help him God. Police report makes no mention, nothing here about seeing anything. He heard a fight, and he somehow wants you to believe that he can hear who punched who first around a corner. Okay? Is his hearing that good, or does he have x-ray vision? But the point is he couldn't see it. You actually have to disregard everything he testified to other than the fact that he heard a fight break out. But since he didn't see it, you can disregard everything else. His testimony was worthless. Okay? Now, I'm not saying that that's going to fly with a jury. A jury might go, whatever, But the point is that there's an art to extracting that key piece of evidence and like I said, putting it on the stand, lining it up for the swing, and hitting it. And the last thing you want is one juror who goes, I think you forgot the good question. Can I ask it? did you see the fight or did you just hear the fight? Oh God. So that's the number one reason that attorneys don't want jurors asking questions. But before I pointed out that number one, you don't want them asking bad questions or incorrect questions or inadmissible questions or inappropriate questions because they don't know which is which. And you can't blame them. They're just jurors. It's not their job to know the law. And then also, no one would like the case to get dragged out longer. Trust me. The attorneys are putting in what they think is necessary. The judge is overseeing the whole thing. You don't need backseat driving from the group of people in the jury box. No offense. Okay, I love jurors. They have a job to do, but we don't need them asking questions. Somebody else asked, "Hey, Steve, how come the jurors, when they go back in the chambers or jury deliberation room, they can't like look up the law or they can't run tests?" And there's a reason for that. Number one is if I said, by the way, the law is in these books behind me, which it is, thousands of pages of laws back there, thousands, literally. And I've actually had people call my office. They say, "Hey, Steve, I think I have a lemon law case." And I go, "Why?" And they cite some law that's got nothing to do with lemon law. I say, "Well, Michigan's lemon law is at MCL 257-1401. They go, "But I found this other section of the law over here." And I'm like, "That's got nothing to do with the lemon law." And they go, "Well, let me read to you one sentence out of it." I'm going, "Doesn't matter. That sentence has got nothing to do with lemon law because that sentence is in the wrong law." So that's that. As for experiments, believe it or not, I've heard stories, and there's a famous case here in Michigan, and I don't even know if it went up on appeal or not yet, but where a guy was accused of killing his wife, and the allegation was that he had karate kicked her because he had taken some martial arts classes somewhere along the line. And back in the chambers, a couple of jurors attempted karate kicking each other, which was ironic because none of them had taken karate. And so the first thing I heard, in my head when I read that was, oh, there's an appeal for you, because I'm not sure if anybody had demonstrated a karate kick in the trial. Was it a front kick, side kick, hook kick, roundhouse kick, back kick, spinning hook kick, straight hook kick, jumping, flying side kick, jumping, flying hook kick, spinning, flying hook kick? Okay, there's a variety of karate kicks. And the idea that someone who's just watched a couple episodes of Kung Fu and maybe 3 Bruce Lee movies is going to attempt a karate kick to see if it would work, okay? The jury is told, you consider what happened in the courtroom and then go back into your chambers and deliberate, or back into your room and deliberate. Deliberate is discuss, argue, debate, talk about, and try to come to a consensus. But it is not go back and experiment and try doing goofy stuff to see if you can recreate one side's theory of this case. And I've heard other examples of people going back and trying to, can we see the evidence? And so they get a piece of the evidence and they start like messing with it to see if they can get it to work. And that's not, you look at the evidence. You can look at the evidence, but you don't tamper with the evidence, and certainly you don't conduct experiments to see if you can recreate something. So those are the answers to the questions about the jurors, but there are some courts that will allow them to ask questions. Quite often what they'll do is they'll say, write the question down, hand it to the judge, and the judge will look at it and decide if it can be asked. That rules out some of the problems, but it does not rule out the issue with respect to the strategy of the guy who conducts, or gal who conducts a really good cross-examination and then has it ruined by somebody asking the last question, which Mowat says is a no-no. Do not ask the last question. Trust me. Questions or comments from below? Otherwise, talk to you later. Bye-bye.